Excellent. Um, Judith, if you could go through and mute people, that would be great. And if you could also mute yourself, you'll make Judith's job a little easier. So thanks very much. Okay, so as we gather today on different traditional territories in Ontario, I wish to acknowledge the deep and enduring connection that Indigenous peoples have with this land. The area I live on is situated on the ancestral homelands of the Wendat, Anishinaabeg, Haudenosaunee, Métis, and Mississaugas of the Credit. In acknowledging the land, I invite each person here to take a moment to reflect on why they are grateful for the land, the connections it fosters, and the wisdom it imparts. Today, I'm particularly grateful for the sky and its ever-changing moods, and also for the trees and the water and the life-giving resources that we are so lucky to have. May we all continue to work towards understanding, reconciliation, and a shared commitment to caring for each other and for the earth. I also want to acknowledge that as we're in Black History Month, that Canada, like many settler colonies, benefited from the transatlantic slave trade, which has left a long and painful legacy of racial inequalities that continue to manifest today. The labor of enslaved Africans helped build this country during the colonial period and beyond. We must not forget the contributions of people who were stolen from Africa by force and taken to lands that were stolen by force, to be treated as less than and segregated in society. We acknowledge the harm inflicted upon Indigenous communities of peoples of African descent. Racism is still prevalent today, and its impacts are real, affecting Indigenous and Black communities in our society. So thank you for giving me the time and space to share that land acknowledgement with you. And now I'm very pleased to welcome our special guest speaker today, Nicole Dietz. Nicole is an articling student in Mandoran Snyder LLP in Kitchener, Ontario. They're changing their name to Bennett Grant later this week on Friday. Nicole attended law school at Western University, where she focused her studies on family and children's law. She worked as a legal researcher for Professor Claire Houston, Western's family law professor. She summered with the Office of the Children's Lawyer and later worked as a legal researcher and writer for the Center for Research and Education on Violence Against Women. Nicole spent 3 years as a caseworker for Western's Community Legal Services, providing free family legal law services to low-income clients. In her third year, she wrote the paper that is the subject of this presentation, and it's just been published this week. And as I said earlier, she's going to send along a copy of that, or has already done so, and I'll pop it in the chat. Nicole will be called to the Bar of Ontario as a lawyer in June 2024. So early congratulations, and then handing it over to Nicole. Thank you so much.
Thank you so much, and thank you for having me today. I'm so excited to share about this topic that I find really intellectually fascinating and also incredibly practical. I hope that you will enjoy it, and there is a slide at the end for questions and discussion, but I am certainly open to anyone jumping in if they see something on a slide that they want to talk about right away. Feel free to stop me, and I have a tendency to speak quite quickly. So if you need me to slow down, or if I just get away from myself, just let me know and I'll bring it back down. So my presentation is about parenting versus parentage. And my paper analyzes the role of intent in Ontario's parental determination regime. And in particular, it looks at a case released in 2022 called Jacobs and Coulombe and Blair and Amiot. And this was a decision of Justice Gregson of the Ontario Superior Court of Justice. So I want to start with some brief terminology just so that we know the same information, you and I. So parental determination is the judicial process of determining who a child's legal parents are, whereas a parental declaration is the judicial ability to declare that an individual is a legal parent of a child. So there is a slight difference, a nuance there. So when I give this presentation and when I talk about this paper, I often challenge people to think about what it really means to be a parent. And this might be hard if you're not a parent. I'm not a parent. I have a dog, so that's as close as I can get. But from my research and from talking to different people, I know that there are a lot of different meanings to parenthood. So some consider, parenthood to be a legal right. You have a right to determine, the health and education and welfare of your child. Other people think of parenthood as something that entails a lot of responsibilities, both legal, financial, emotional, and other responsibilities. Some think of parenthood more as symbolism. It symbols a special type of relationship between parent and child. There's also a social, personal, and legal identity that can come from parenthood that can help people see themselves as a parent. It plays into both the identity of the parent and the identity of a child. We also want to think slightly about what the role of the state is in governing families. And this is one area where family law is really interesting because we have that unique mix of public and private law that, the state wants to be involved and have some say, but they also, have some, provide families some privacy to manage their own affairs. So the role of the state is also an interesting component in what it means to be a parent. So um, some of you may be familiar with the Jacobs decision. I've heard it spoken about at multiple CPDs put on by various groups over the last year. But proceeding as if you don't know the facts of the case, I just want to do a short poll. You don't have to vote or raise your hand, just think about it internally. So here are some of the facts. So my question is, who should be the legal parents of Isabel? So J and C are two gay men. They've been in a relationship for 10 years. They wanted to have a child together, and their friend B agreed to be their surrogate. B was going to be a traditional surrogate, which means that she would use her own egg or ova, and she would use either J or C's sperm to fertilize one of her eggs. And they even went as far as to start this process and look into assisted reproductive technologies that could assist them. J, C, and B, so the two gay men and the surrogate, agreed that J and C would be the parents of any child conceived. Then B meets a new man, and his name is A. He becomes her boyfriend, and they have a pregnancy scare. After this pregnancy scare, B says to J and C, would you take any child, even if they were not genetically related to you? And J and C agreed. Later, but before B could be inseminated with J or C's sperm, B and her new boyfriend actually did conceive a child, which B called an, quote, oops, unquote. B, the surrogate or biological mother, asked J and C if they would still be interested in taking the child and raising the child, and the two, J and C, said yes, they would like the child. So before birth, J and C, as the two prospective fathers, applied to the Deputy Registrar General to be legally recognized as the child's parents, and they didn't get a response back before the child was born. So the child is born, J and C name her Isabel, and they take her home from the hospital, and they begin to raise her as their daughter. Notably, though, A and B, so the biological parents, were listed on Isabel's birth certificate, and J and C were not. And this is because there's rules in the Children's Law Reform Act about who can be listed on a birth certificate at birth. So when Isabel is 4 months old, the Registrar General responds to J and C's request to be listed on the birth certificate, and they deny J and C's application because they said this is not a true surrogacy or an adoption that has gone through the formal required channels. On learning of this, A and B, the biological parents of the child, decided they want Isabel back. So J and C respond by bringing an application for a declaration of parentage to become the legal parents of the child. The case was not heard until Isabel was 18 months old. She was a year and a half. And during this time, J and C were the social parents and primary caregivers of Isabel and continued to raise her. There was some visitation and access between the biological parents that was facilitated by J and C, but this all was in the COVID era, so it was limited. So at this point, I usually ask the audience or anyone I'm speaking with who they think should be the legal parents. And usually there's mixed response depending on which kind of camp you fall into. I think the camp that I fall into is that J and C should be her parents. And I think, you know, I say that because I think it's relatively clear from my paper, if you read it. So what the judge ended up holding, Justice Gregson denied legal parentage to J and C, although she awarded them full decision-making responsibility, which is the new terminology for custody with respect to Isabel. They were also awarded her primary residence. And B and A, the biological parents, were awarded some parenting time. So why wasn't this a surrogacy or adoption? So it was not a surrogacy because in a surrogacy, you need to have a written preconception agreement to engage in a surrogacy, and this is required by the Children's Law Reform Act. And it's not an adoption, which could have been an option post-birth if the parties pursued it. But since the child was already born, you would need the consent of the biological parents, and they were not willing to consent post-birth. So we're kind of in a weird spot, not really sure what rules apply here. So the place to look for an answer in this case was within the legislation. So I'm going to go over what the Children's Law Reform Act entails. And I apologize, there's several provisions here. I'm going to try to focus on the ones that are most important. And these provisions are in my slides, so you'll have access to them if you'd like to review, or you can review the legislation itself. So in terms of legislative background, Ontario's parental determination regime underwent significant changes through legislative amendments through the All Families Are Equal Act in 2016. And there was a desire amongst the legislators to provide for greater certainty and equality within the parental determination regime in Ontario. And these themes of certainty and equality are very evident in the Hansard debates and the research put forward before the legislature when these laws were being introduced. And as a result, there is an entire section in the CLRA called Rules of Parentage, and it sets out who is a parent, how to become a parent, etc. So here are some of the rules. So section 4.2 of the CLRA says that except in the case of an adoption, parentage is determined according to sections 6 to 13 of the Children's Law Reform Act. So a brief overview of what's in those sections. Sections 6 and 7 set out that traditionally conceived children, the birth parent is the legal parent of the child. This is a presumption in favor of biological parenthood, and so you have to rebut this presumption if you are going to be a legal parent to a child. So that is why we would need something like a surrogacy agreement to help to rebut that presumption. Section 8 says that where a birth parent of a child who is conceived through assisted reproduction had a spouse at the time of the child's conception, that spouse is a parent of the child if they consented to the child's conception. So not entirely relevant to this case. Section 9 sets out that 4 parents can execute a pre-conception parentage agreement in very narrow circumstances, which do not apply to the present facts. Sections 10 to 11 sets out who the legal parents are in surrogacy arrangements and the requirements for having a surrogacy agreement and having all of those details figured out and formalized before conception. And section 12 deals with posthumous reproduction, which is also a really interesting topic that has kind of been popping up in family law and estates law within the case law of the last couple of years. So the section that really matters to my paper and to Jacobs and Coulomb in this case is section 13, and it sets out where the court can make a declaration of parentage. So we will go through that provision now. So section 13.1 says anytime after a child is born, if you want to apply to become the legal parent of that child, you can. You have to have an interest, which is not well defined in the case law. We have an exception for adoption children, and we have under 13th sub 3 the ability for the court to make the declaration if they are satisfied that that person is or should be a legal parent of the child. However, there's more to this section. So there is a restriction, despite the ability to make a parental declaration. The court shall not, and those words are important, shall not make the following declarations of parentage unless the conditions set out in subsection 13.5 are met. So when does 13.5 apply? Only in these two scenarios set out in subsection 4. So where a declaration of parentage would result in the child having more than two parents, or where the declaration results in the child having, as a parent, one other person in addition to their birth parent, if that person is not a parent of the child under section 7, 8, or 9. So the one that's important for our case is the first one. In this case, if the judge made a declaration of parentage, then Isabel would have more than two parents because A and B are already legal parents on the birth certificate, and J and C would also become legal parents. So because of that, they have to meet the conditions set out in subsection 5 of this piece of legislation. So here is subsection 5. The following conditions apply for a declaration of parentage to be made where a declaration would result in the child having more than two legal parents. So 1, the declaration must be made on or before the first anniversary of the child's birth. So the child has to be 1 or under. In our case, it wasn't a problem because the application was brought when the child was a few months old. The next condition is that every person who is a parent of the child must be a party to the application. So you have to name them and put them on notice. 3, and this is a very specific one and is essentially the heart of my paper, is that there must be evidence that before the child was conceived, every parent of the child and every person in respect of whom a declaration of parentage respecting that child is sought under the application must have intended to be together the parents of the child. So what does that mean? It means that if these 4 people wanted to all be the legal parents of the child, that before the child was conceived, they all had to share mutual intent that all 4 of them together would be the legal parents of this child. And the 4th condition is that the declaration must be in the best interest of the child. So moving along here, I'm going to share my thesis with you, and you'll see this in my paper if you spend time reviewing it, is that the requirements of this provision hamper the goals of certainty and equality because they prevent parental declarations in cases that fail to meet what I consider to be a very rigid legislative condition. And the legislation also fails to consider how families form and develop after conception. So in this case, just so we're, again, all on the same page here, we want to look at what really in this section obstructed J and C. So there's not a surrogacy nor an adoption, and the child already has 2 legal parents. So we know that the judge under 13.5 can only make a parental declaration if all of the following factors are present. So 1, the application must be made before the child turns 1. In this case, that was met. The application was brought when Isabel was a few months old. It's also required that every other parent would be a party to the application. Again, Jacobs and Coulomb did name the other parent or the 2 legal parents in their application, so that was also met. However, in terms of whether there was evidence of preconception intent of every parent of the child, that all parties intended to be together the parent of the child, that wasn't present. And because that wasn't present, the court did not go on to consider the best interest of the child. So the outcome was that Justice Gregson felt she could not declare J and C to be the legal parents of Isabel because of this section. She found that the parties shared no mutual intention to become the legal parents of Isabel. Firstly, because the pregnancy was an accident and it wasn't fully planned, and it was not planned to produce a child for J and C. And secondly, the parties, specifically J, C, and B, only wanted J and C to be the legal parents of the child. In addition to that, another obstacle was that A had not consented or shown any intent to donate his sperm to create a child for J and C. So I have some concerns here on the slide. These are concerns that came up before I started writing my paper. So these were very preliminary concerns of mine, and I'll share them with you. So my one concern was, well, it's been 18 months, and J and C have been these functional parents to Isabel for the entirety of her life. She's now almost 2 years old. She's really attached to them, and the judge said that JNC took really good care of Isabel. So does that matter, or should it matter? Further, A and B knew prior to becoming pregnant that JNC would take any child conceived by them. Does that matter, or should it matter? JNC were also the functional and social parents of Isabel. Should that matter? So these were some things that were in my mind as I wrote. So after the case, I have some updates for you. Jacobs and Coulombe appealed the case, and it went to a case conference before Justice Madsen, and the parties were able to settle. So in the settlement, Blair and Amiotte agreed that Jacobs and Coulombe would become legal parents of the child. And in exchange, there would be an increased parenting time to Blair and Amiotte. So an issue with this, though, is this is a settlement. It's not a reported decision. The original judgment is still good law, and it did accurately apply the legislation. However, I think, and I hope that I'll convince you of this, that the outcome is contrary to the legislation's stated purpose. I want to just also mention that Justice Madsen in her endorsement did cite the declaratory power of judges under the Courts of Justice Act to make the declaration, and I don't know how to pronounce this correctly, her parens patriae jurisdiction, which is commonly referenced in these types of cases, but we are a legislative supremacy jurisdiction, and so technically the legislation can be held as superseding or having precedent to judicial decisions in this regard. So even though we've kind of found some ways around these requirements, it's not necessarily determinative of the issue. So my main issue here is this idea of preconception intent. I think it is really, really narrow, and it has to exist at a very specific time. And I think it will prevent people from obtaining parental declarations through the court, and where the family has formed over time, or where things just weren't formalized correctly, like in Jacobs and Coulombe. And I do canvass other cases of this nature in my paper, but I'm not going to fully get into those cases today, just in the nature of time. So here's how I broke down my paper. Part 1 was an overview of the case and the legislation and on the role of intent in our province's parental declaration regime, whereas Part 2 proposed that other factors other than preconception intent should be considered when we're making these parental declarations or determinations. So why is preconception intent even a requirement? So why does it need to be present before the child is conceived? And my concern is that this ignores authorities that are out there that support the principle that loving families can be and are created after birth. And here I've also listed some other problems with focusing only on preconception intent. So like I said, it has to be present at a very specific time, but a child is a child for 18 years plus 9 months, give or take, and they often rely on their parental figures into adulthood. And like I touched on at the beginning of my presentation, there's a lot of different factors that influence identity and parenthood and what it means to be a parent. And to be a person's legal parent can have an impact on that child for that amount of time. I also think that relying specifically on preconception intent fails to provide certainty, and it removes judicial discretion and the best interest of the child test from the analysis. Whether that's for better or for worse, I think is something that could be debated, and certainly it was in some ways debated in the Hansard debates, but I think it deserves a little bit more attention than perhaps the legislation is giving it now. When assessing preconception intent, often the court will have to look at physical facts, states of mind, or both. And this fails to consider a child's welfare. It's just looking at a screenshot, a snippet of time. I also noticed in the literature that there is a disconnect between legal parenthood and psychological or social parenthood, as I often refer to it. And by having this requirement of preconception intent, we're perpetuating that disconnect between those two types of parenthood. Another note that I credit to the professor, Professor Noy Naman, who supervised my paper and who was the professor involved in my research, he, in his own paper, characterized family planning as a class-based, racially selective luxury. And by focusing on preconception intent, we're rewarding that family planning, which gives some individuals in our society more of an ability to meet this strict criteria. Another point that I want to share is that judges aren't happy with the legislation. It's clear from Justice Madsen in this case specifically trying to get around it. And there's other cases, AA and BB, which is an Ontario Court of Appeal case, and another Justice Madsen decision from 2017, ML and JC, that they're trying to get around this. And this to me signals that the legislation might not be capable of giving a result that the court thinks is acceptable or fitting. And I also think another reason that this strict requirement of preconception intent is not as good as perhaps it was set out to be or thought it would be is that it's much easier for heterosexual couples to establish than those in untraditional relationships who have to put out a lot more effort to have a child because the ability to produce one naturally isn't necessarily an option for them. So intent, I still think, is valuable at the end of the day, despite all of what I've just mentioned. I don't necessarily think it has to be present at that moment of preconception, but it has developed, intent has developed as a mechanism to assist us in parental declarations and determinations over the last 30 years, and it's a tool used in multiple jurisdictions. It shifts the focus away from the bionormative idea of family, and it shifts that focus onto the mutual commitment of individuals to raise a child together. And really, that's what the legislation is wanting to pursue. It wants to make sure that the people recognized as a legal parent are committed to being that parent of that child. It also appeals to people that are favor the ideas of reproductive liberty and choice and fostering gender neutrality. So to say, you know what, I would like to have a child on my own or with a same-sex partner, I'm going to decide to do that, and I'm going to take steps to ensure that can happen. And having intent be present in the analysis is helpful to establishing that those people are committed to raising the child. It's also really useful for families using assisted reproductive technologies. Intent is also helpful because the legislature, based on the Hansard debates and the laws it's written, doesn't seem to want judges to have full discretion over parental declarations by using only perhaps the best interest factors. But like I said, relying on preconception intent does place significant weight on choice and can de-emphasize the role of commitment and dependency. So when I was researching for this paper, I just thought, well, what do we do about this? We don't really, there seems to be pushback against judges just having the power to make these declarations, but judges don't think that the legislation, or they seem to be signaling the legislation isn't quite working for them. So my thought was, well, maybe we need to just, instead of broadening the whole analysis and letting judicial discretion and the best interest usurp this process, maybe we just add another factor. And I didn't want to just make one up. So I researched what other jurisdictions do, and I've pulled actually from the Wisconsin Supreme Court, where they use the factor called function to assist them in their parental determination regime. So I will share what that is with you. Function, my proposition is to add this into the analysis. We can consider how a family functions both before and after birth, while still considering intent as a factor. And so this would look like the following. So we would look at how the psychological or social parents develop into the role that they are occupying, and whether that was supported by the legal or biological parent. Can also look at whether the psychological parent took on parenting roles and parenting obligations with respect to the child. So did they live together? Did they provide emotionally and financially towards the child? What were they doing day to day with the child? What was their level of involvement? What's their role? And we know that the court is good at figuring this out. They do it all the time in family cases and cases involving children. So this is a skill that judges already have. And we would also then consider whether sufficient time had passed to solidify the parent-child bond. So in the Jacobs and Coulomb case, it's it's hard to say, you know, if they returned Isabel to her biological parents at 4 months, would that have been a solid parent-child bond between Isabel and J and C? Or is the fact that this case wasn't heard until the child was 18 months more likely to, you know, show that significant or sufficient time had passed? So that, I think, would have to be something more in the discretion of a judge, and on a case-by-case basis, depending on the nature of the relationship and the length of time involved. So why do I think this is important for mediators to be considering? I think that it's important for mediators to canvass parenting and parentage issues with your clients and be aware of the legislation's constraints, so you can flag any issues that you might find in dealing with your clients and different parties involved. Another really important role that mediators can play in this space is coming up with creative solutions. The legislation is really restrictive, and you might, you know, just based on the judge you get or the circumstances, you might not, or you might end up with a judge willing to circumvent this legislation. And Jacobs is still a good decision. So if you can come up with a creative solution where, similar to Justice Madsen, there's some give and take on both sides to achieve the results that the parties are desiring to effect, I think that that's really a strong place for mediators to be, because you're not, like a judge, constrained to the legislation. You don't have to follow it to a T, like Justice Gregson endeavored to do in this decision. This is especially useful with mediation because these situations are often really nuanced, and the family reality isn't that of the nuclear family. And as our society progresses, we see more and more of these situations, more and more families deviating from that model of the nuclear family. And this is a good space for mediators to engage and help to structure relationships and arrangements that can consider those nuances maybe better than the law currently can. In these cases where you might be dealing with parental determination, I think that you should, and this is my opinion based on my paper, assess for factors that do support intent and support function. I think you should look at what the arrangements were before the child was conceived and what the parties had turned their mind to and agreed upon. And then I think you should look at the reality of how the situation has played out and how old the child or children are and what type of relationships they have with their parents. I think another thing to be aware of is that we have these non-traditional family types, and they may require your services to navigate these really complex issues. They're very emotional issues that, like I said, can be really tied to someone's identity. And you might have to pivot your approach based on the number of parties, the number of prospective or intended parents, and the positions that they take. Particularly where it's not just parent one and parent two, and you're dealing with two sides, you could be dealing with 3, 4, or potentially more sides in these types of disputes. Whether or not that's something that mediation can effectively handle, I think it would depend on the case, but I think that it's certainly worth trying. And lastly, I just would flag again, based on what I've learned from this case, adoptions and surrogacies have very specific legislative requirements. And if they go wrong, you could end up in a situation where your parties are stuck under Section 13(5) of the CLRA, which, as I hope that I have convinced you, is quite restrictive at present. I also have included some points that are more based on lawyers, but I think that they also can help you inform your approach as a mediator as to why this could be relevant for lawyers as well. So additional reasons for this to be on your radar. In family law, I think we'll see more cases where we have non-traditional families and the increased use of assisted reproductive technologies. We may have implications for child support where there are multiple legal parents, and I don't know that our current regime is set up to best consider that. We might have to look at things like how step parents might have to pay support as perhaps a basis for a model that would involve a non-traditional family type. And we might have new issues arising in parenting disputes just generally because there's more parents involved. In an intestacy, One issue that I flagged really early on in my research is a child who's not the legal parent of, or sorry, a child who's not the legal child of their social parent doesn't receive under an intestacy under the Succession Law Reform Act. And so it can be really critical in these cases to have a will and a valid one, or to have a parental declaration there to protect that child in case there is an intestacy. In terms of dependence relief, I think that a child in these circumstances could potentially receive dependence relief, even if there isn't an intestacy based on the settled intention test to become a parent. But again, that's going to be very fact specific and case by case. And I think that there could potentially be a charter challenge of this legislation on equality grounds. I'm not the first one to raise this, and I don't canvass it in full in my paper, but there is a footnote that gives credit to some authors who have canvassed this before. And I think it's a really interesting issue that could certainly end up before the court if the right fact scenario presented itself. So out of the litigation realm, there's also work on the solicitor's end that could be relevant, just the way that you handle your mediation or some recommendations you might make. So wills, we want to make sure that there is adequate provisions for non-legal children in a will and protect them from disinheriting on an intestacy. We know that you can put into a will some care arrangements for a period of time post-death, and it might be wise to put some arrangements into the will, even if someone is not the legal parent of a child, just so that there's that added context. And I think also we'll see this again with the disposition of frozen genetic materials, which is less related to the case that I've researched, but does have some similarities. So I thought to include that as well. In contracts, I think we could see an increased demand for fertility contracts, and I think that mediators could end up in the position of helping to negotiate those surrogate agreements, gamete donation and parental and parentage agreements. And then just generally, we'll continue to see the use of assisted reproductive technologies rise. The social science data does show that their use is increasing, particularly as people are waiting, they're becoming a little older before having children, or we have non-traditional family types that can't naturally produce a child. And so when these technologies are used, there is going to be some legal work needed, and the law will undoubtedly be faced with new questions regarding these issues as they arise. And in that regard, I think amended or new legislation might be required, particularly with regard to Section 13, Sub 5 of the Children's Law Reform Act. So we'll see where that goes. From what I understand, this is still a topic that is on the radar of various judges. The lawyer who handled the Jacobs and Coulombe case on behalf of Jacobs and Coulombe, her name is Emma Katz, and she works out of Kelly Jordan Family Law in Toronto. I've been in communication with her, and she seems to be still interested in where this is going, even though that case has settled. So I'm not entirely convinced that this is an open and shut case or a one-off case. I think that there will be the need to continue to address these issues going forward. And with that, I conclude my presentation portion and would be happy to open the floor to any questions or discussion.
Nice. Okay. Thanks so much, Nicole. I really was happy to hear about the links to family mediation and where it might be able to be used and what to be cautious of as family mediators. The chat is open, and you are also able to unmute yourself if you'd like to, or maybe we should be, there's a lot of people here. So let's put our hands up and try to answer questions, ask our questions that way. If you can use the hand up button. Or wave wildly.
It's also okay if there aren't any. No pressure.
Yeah. Interesting. Very interesting case. Are these common, Nicole? These types of cases? Did you have others to choose from, or was this a very unique case?
This one was pretty unique. I
Yeah.
think like there's some quotes in this judgment where Justice Gregson says things like, well, we don't want people just handing off kids like a football. And I think that's really a relevant consideration. And I think that
Mhm.
that's kind of going to the heart of why the legislature is so concerned with wanting this consent there at that narrow and specific point in time. But I don't know that that is the only consideration that should be before our court and before decision makers or the legislature within the legislation itself. So I think that there is um, something to be said for that. In terms of other cases, there's some cases out of British Columbia. I think there's one main case, and then there's a few local to our jurisdiction as well that are mentioned in my paper where similar but not exact situations have arisen, and the courts are, as I mentioned, kind of trying to get out of being pinned to this narrow constraint of preconception intent. So there certainly are other cases, nothing on par with this particular case. It's really an interesting and novel set of facts. And I recognize that the facts are novel, but I don't think that because the facts are novel, our law needs to be so strict and stringent and have a novel approach.
Right. And so in mediation, if this group of four people had come to an agreement that, you know, that was satisfied them, I guess one of the biggest warning signs is the intestee passing away of someone without a will, and that child may not have legal rights to the social parent that they have. Was there anything else that was like that couldn't happen in mediation? Like if they were able to reach an agreement, is there any sort of more like points we should be aware of as mediators?
Off the top of my head, nothing is coming to mind. I think a general awareness just that this issue exists and that there are strict requirements, not only in this sphere, but also for surrogacy and adoption. Um,
Right.
you don't want to accidentally be outside of the scope
Yeah.
of what the type of arrangement you're trying to make, because it can get really messy and really contentious quite quickly. But I do think that that's a really good spot for mediators to step in if possible, because the legislation is quite restrictive. I think that there's more ability for creative solutions to come out of mediation, and for people to really make sure that they're feeling heard and the arrangement is suitable for them.
Yeah. And do you think COVID affected this case because of the timing?
Absolutely. I really wonder, and I struggle with this when I think about my own paper and my own research, if COVID hadn't delayed this getting in front of the courts till the child was 18 months old. Like I don't know if things would have been different. I don't know if there would have been, an order made that the biological parents should have more or sole decision making over the child, or more parenting time over that child. But perhaps that factor of the child being in their care for 18 months and having a really strong relationship with the two dads, I do think that that helped the court, and swayed the court to continue to allow them to have full decision making, so full custody of the child. And that's where I struggle, because you end up with this very paradoxical result where these two dads are doing everything they can for this child. They are awarded custody of the child, but they're not the legal parents.
Yeah.
So that can impact their identity as parents, and I think raises some equality concerns that, these two gay dads are having this issue, but if it were a straight couple that produced naturally, that the same issue wouldn't necessarily be present.
Interesting. Okay. Any questions people want to ask Age? You look like you're waving. You'd like go ahead, Age.
Yes. Well, it's interesting to note that today on the CBC Morning Show, they had a psychologist from U of T on who talked about the fact that kids recognize the voice of the mother before the father, and that's because they bear the child. But in this case, the two parents, if they were both involved, would recognize the voices and therefore bond more with the gay couple, the parents, than with the biological parents. So, to me, not being a lawyer, but having worked with kids all my life, whatever is best for the child in this case should be the outcome. And those two people who worked with this child, cared for this child, they should be the parents, because what may be very important at some point to know who your biological parents are. On the other hand, you like to know that the the child doesn't have to undergo trauma. And there would be trauma if you take this child and just say, well, sorry, now you're going back to the other couple. You really don't know yet, but now the 18 months is a long time. But it was interesting to listen to this conversation earlier today, because it meant that dads should really step up to the plate and talk to their children right from the day they're born, and maybe even talk to the belly before they're born, to get equal footing with the mothers or close to it. So just my thoughts at the moment.
Thank you. That's really good context. I think it definitely plays into why we should have some judicial discretion in this analysis before the courts, and a mediator's perspective might help to have the parties understand how those relationships are going to impact the child, and perhaps what arrangements could be made to slowly increase their exposure to the parents that they haven't spent time with, while still ending up with some type of agreement or arrangement where people still feel like they are socially and legally identified as the parent of the child.
Not to mention the child could read about all of this and all the, disagreements that the four people who loved her had, and that's all very public information, which is something that she can access one day.
Absolutely.
Yeah. Any other questions or reflections? This has been a really interesting conversation. Anyone else want to weigh in?
Can I just ask a question?
Sure, Paula.
I want to say forgive me so much because I got caught in a meeting. So I've been listening, fascinated with a couple of facts missing. So if the rest of the group will forgive me. So there's the two dads
Yes.
that had the child in their care for 18 months. I understand Justice Madsen, it's settled. But if she had to apply the law, are you saying the outcome would have been different?
So this is where things are a little gray. I actually had the chance to speak with Justice Madsen about this briefly. She's a local judge to me, and I've seen her at some events. She felt she could rely on her, and I'm going to butcher it again, parents patriae, and
Correct.
the declaratory power under the Courts of Justice Act.
Yeah.
And I have received a copy of the endorsement that she made when the parties settled that stated parental declaration, or a legal declaration of parenthood would be granted to Jacobs and Coulombe. And she relied specifically on those two elements when she made that endorsement. Whether she needed to, I'm not sure, because this was done on consent. It settled. So the parties consented, but she still put that in her decision. And in her 2017 decision in the case ML and JC, which is referenced in my paper, those are the two things she also relied on. And those arguments were presented to Justice Gregson, and Emma Katz was kind enough to share a brief summary of the submissions that she made on those issues. But Justice Gregson doesn't touch on it in her judgment very much, and she applied the Children's Law Reform Act more strictly in light of that.
And so again, forgive me, the group, I'm just fascinated. So the dispute, there was an accidental pregnancy between the couple and the baby ended up with the gay couple. So how did the dispute arise?
So the two gay men, J and C, they had been together 10 years. They wanted to have a baby, and one of them went to college with the biological mother, and she was good friends with them and said, yeah, I'll be your surrogate, no problem.
Okay.
So they start arranging for this to all happen, but before they actually arrange this, or before she's inseminated, she gets up with a new boyfriend who she'd only been with a few weeks. They have a pregnancy scare. She says to the two gay dads, J and C, hey, would you still take a child? I had this scare. And they said, absolutely, we would. So sure enough, a few weeks or a few short months later, she ends up actually pregnant, which she called an oops. And she had only been with the biological father for, I think, about 3 months at the time. And so she asked again if they would take the child, and J and C said that they certainly would. And so they they operated the four of them as if
Mhm.
JNC would take the child. They took her home from the hospital. They named her. And it was only after the Deputy Registrar General for Ontario declined to grant legal parenthood on the basis of the facts alone that the biological parents said, well, we want her back then. So then that dispute arose as a result when the child was 4 months old and was slowed considerably because of the COVID pandemic, and the case ultimately wasn't heard until the child was 18 months.
I apologize to the group. Thank you very much for filling in
Of
those
course.
gaps. I realize I
And
was
thank
asking you to repeat
No
yourself.
worries.
Thank you.
No worries, Paula. I actually thank you to you as well. You spoke, if I remember correctly, to my children's law class when I was at Western Law 2 years ago during the January term, and I still remember some of the things that you shared. So I thank you to you as well.
Thanks.
Ashley?
That's Dan, I think. Yeah.
Oh, Dan. Sorry, it's just
Yeah.
the name.
It says Ashley. Yeah.
It's a Zoom conflict issue, but anyway, I appreciate the discussion. It's fascinating. I guess I'm interested in that applying the law, where applying the law intersects with the best interest, because it seems to allow judges some discretion, although if increasingly maybe the flaw will be dealt with at some point legislatively, but. The discretion allows, it can allow, either on consent or by discretion of the judge, fairly complicated arrangements that can be fairly problematic, I can imagine. And I'm just wondering down the road if this is going to be an issue, if there's more discretion used based on best interest, that the judges are circumventing, as you say, the restrictive aspects. Is potentially this could open up other problems if these parties don't get along and the child's caught in the crossfire. I mean, I think what Aggie's saying is quite true, that best interest should, but it's not always. I always thought best interest was the overriding factor, that judges would have that discretion. But I guess some judges are willing to do that, and others are not. So it gets fairly inconsistent then in terms of how it's being used. But it's an example of, it really takes a village to raise a child. And I think it's an illustration of how, in these cases, how many people really want to be involved in the child's life. And on the positive side, that's probably a good thing, but it can be really complicated if the arrangements, possibly on consent, have a complexity to it. And down the road, I can see that some of this stuff may come back to court again. And then I don't know what that's going to mean then in terms of possible litigation. Hopefully it can be avoided, but because it's based on discretion, it's not there. Again, they're not applying the law as it states, and even though it's problematic. Anyway, that's kind of a comment. I think when I see grandparents who kind of are facing this kind of thing,
Right.
And I don't know if that's other folks would want to comment on that. How that seems to be more and more the case. Grandparents are raising grandchildren without any change in parentage, and then it presents a problem down the road at some point. I mean, it also weighs into child support, decision making, et cetera, et cetera.
Absolutely.
Anyway, that's it. Thank you.
One other thing, sorry.
Go ahead.
I'm not going to get on I'm an adoptee podium here, and how biologicals don't get it often. But I think you talked about a number of, class bias, these bias. There's a biological bias, right?
Of course, absolutely.
That is huge. Either to diminish the role of the importance of birth parents to adoptees, and then also the parentage. So it's not an either or, it's both and. And I think, if I can be so bold, I think this is often missed. I did 1.5 master's degrees, and I can tell you, as an adopted person, I think, it was alluded to twice as a footnote, right? So anyway, that's the end of my my biological
Absolutely.
note. But going through court, we talk about best interests, right? So if we're going to be ageist and classist and all of that stuff, if we talk about a white, middle-aged or older man, heterosexual, what is best interest of a child in such circumstances?
I completely agree with you. That was one of the things that I struggled with a lot. And there's a really interesting two papers actually by Noy Naman. His last name is spelled Naaman, and he touches on some of those things that you have discussed. And I think he does a really good job of canvassing those things, and he does a really good job of explaining, you know, there's risks on both sides. You can overemphasize the role of a biological parent, but you can also severely underemphasize it.
Yes.
And so striking that balance, I think that that's kind of what we're seeing the legislature struggle to do here. But we then see the courts, you know, struggle to apply it. So we're at that interesting intersection where it's not quite clear to me how this will continue to unfold legally, or what might be in store in the future, but I'm certainly interested in continuing to see where it goes.
It's fascinating, isn't it? And as you alluded to in your conversation, Nicole, like the changing shape of the family and what we're all going to be trying to help, you know, is no longer the nuclear family as we go on to the our next years together as family mediators. So thank you so much for your presentation. I've really enjoyed it, and I think others have too. Great turnout today, great questions. If you would like a copy of the PowerPoint or the Nicole's article, which is published already in something called West's Publishing.
Westlaw. If you're a lawyer, I'm sure you know what it is, but if you're not a lawyer, you might not.
The first, you said the first two, Thomson, is it Thomson?
Thomson Reuters, their
Thomson
legal research
Reuters,
platform.
I know. Okay.
Yeah.
So you can get it there, or Nicole's kind enough to email me that too, and a copy. So if you would like that, just email me. You know my email. I'll pop it in the chat here, director@OAFM, and I will send it to everybody. And then you can just shoot me an email. You know, later on today, Nicole's gonna send me her stuff after. I'll email you back with the information, and we're gonna pop this on the OAFM website too.
Great. Thank you so much, Marianne, and thank you everyone for having me.
Thank you so much.
Yeah, it's been wonderful. Thank you. Have a
always
wonderful
happy
day.
to talk about this stuff if anyone wants to reach out.
Awesome.
If you're chatting me, please email me because I don't keep the chat, and it will be much easier for me. So email me and I will email you back. Thank you.
Take care. Thank you.
Thanks. Okay. Lots of congrats and thank yous in the chat, Nicole. So nice to see you, Archana.
I know, it was wonderful. Very nice presentation.
Oh, so good. So what an interesting case.
Yeah.
Yeah, very good.
And looks like interesting topic for people too.
Yes, for sure, for sure. Oh, hang on, I'm gonna stop recording.
Hey, Judith.